Good day everyone, welcome back to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule, and in today's episode we will unpack what if an employer dismisses an employee when there is no agreed or fixed retirement age. What are the applicable legal considerations and implications? It too often happens that an employer tries to phase out older employees. This could be for a number of reasons, including nepotism, resistance to new technology, youth-driven management, perceived inefficiency, or personal biases. While some of the motives mentioned may seem justifiable to certain individuals, legally, an employer cannot simply force an older employee to retire before the organization's normal or agreed retirement age. In order to be entitled to retire an employee, Section 187(2)(b) of the Labour Relations Act effectively requires there to be a normal or agreed retirement age. If such normal or agreed retirement age does not exist, the employer will have a problem retiring aged employees. The Labour Court case of Helgaard Andries Slabbert v. Muji Motor Group confirms this point of view. The employee in the matter was employed in terms of an oral agreement concluded on the 1st of February 2003 as a sales consultant. The agreement made no mention of a retirement age, nor was the matter discussed and agreed upon later in the employment relationship. Accordingly, there was no normal or agreed retirement age between the company and employee. On the 3rd of August 2020, the employee attended a meeting with the sole director of the company. During the meeting, the employee was advised that he had reached retirement age based on what the company argued is a normal retirement age of 65 in the motor industry. The employee was now 72 years old. Thus, the company proposed an option for the employee to continue earning an income from the company post-retirement on a sales commission basis. The employee rejected the offer. Immediately after the meeting, the employee was served with a notice of retirement. In the motor industry, the Provident Fund collective agreements regulate and mention a retirement age of 65 years. Membership, however, is compulsory for only certain categories of employees employed within the motor industry. Employees who fall within the registered scope of the motor industry and who are not obligated to become members of the funds may be admitted to voluntary membership at the sole discretion of the regional council concerned. The employee was not a member of the Provident Funds, and there was no averment by the company that he fell within the registered categories of employees obliged to join the funds. It was the company's argument that the employee was given notice of the termination of his employment due to having reached the industry retirement age. The collective agreements stipulates that all employees in the motor industry are members of and are bound by the provisions of the agreements. The agreements specifies the retirement age as 65 years. The employee's retirement age during his employment was always 65 years. The employee, like all other employees in the motor industry, should reasonably have known that the age of retirement in the motor industry is 65 years, and consequently, the retirement age stipulated in the agreements applied to the employee, regardless of whether he was registered with the council or whether he was or is a member of the funds. And lastly, the retirement age of 65 years was a condition of the employee's employment in the motor industry. The court accepted that the company was entitled to retire employees at any time after reaching normal retirement age, even if it was 7 years after reaching normal retirement age. However, the court disagreed that the normal retirement age was 65 years. This was because it established that 65 was the retirement age for employees who worked in a different capacity to that in which the employee had worked, as the company had not established any normal retirement age for the employee or for employees who worked in the same capacity as he. the company found that no applicable normal retirement age had been established. Consequently, as the company had admitted that it had terminated the employee's employment because he was 72 years old, the court found that the employee had been automatically unfairly dismissed due to his age. The employee was awarded 12 months remuneration as compensation plus cost of suit. In summary, colleagues, if there is no mention of a retirement age and there's no organizational norm, then an employee can continue to work until they are unable to do their job properly. The employer can only terminate the employee's services for reasons related to either misconduct, operational requirements, or incapacity, and will have to follow the procedures set out in Schedule 8 of the Code of Good Practice Dismissal. Employers must be careful when dealing with retirement to avoid costly mistakes. That brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.